Hello, my name is Scott Goldschmidt. I'm a partner at Thompson Coburn LLP in the higher education practice, and I'm pleased that you're here to join me for the second version of the Higher Education Reg Rundown. For the next 20 minutes or so, we're going to be talking about the Biden administration's final Title IX rule, which, if you're on this call, you probably know, was recently published in the Federal Register. For those of you that may not know, Thompson Coburn is a full-service law firm with offices across the country and a dedicated higher education practice, meaning they're individuals like myself, there that spend all our time dealing with higher education institutions and thinking about how best to serve them. We don't have much time here, so let's just jump right into it. So as I previewed, the Title IX rule in its final form was published April 29th in the Federal Register. Along with the rule, the department also published a few helpful resources that, if you're not familiar or haven't dug into the couple hundred-page rule, might be helpful to kind of start your journey. So the first of those is a fact sheet, which just provides a high-level overview of the rule. They also published a summary of major provisions and a resource for drafting Title IX discrimination policies, notices of non-discrimination, and grievance procedures. And that resource actually does have some sample language for institutions to use so that you can use that as a starting point for new policies. Really important, and we're going to mention this a couple times during the presentation, but the rule is set to take effect August 1st, 2024. That is not much time. I know that might seem like far away, but for all the things you're going to have to do, and hopefully, as you'll see at the end of this short presentation, there's a lot to do before then, and so we want to try and provide this resource to get your thoughts organized and to try and figure out how best to achieve compliance by that time. Before we jump into the changes in the rule and a couple things we want to highlight, we do want to mention that Thompson Coburn is prepared or is planning to redo its higher education training series. As some of you may know, in 2020, we took part in a 6-part training series with myself, Aaron Lacey, and a few other members of our team that really went into the rule in depth. We're going to be doing that again. This rundown is just for a high-level overview to kind of give a sense of what the high points and the basics of the rule are. But stay tuned, potentially later this summer, for that in-depth look. An in-depth training series is going to be free for institutions of higher education, and be pleased if you guys look at it and use it again. Also wanted to mention, we do have a higher education resources page. This video, along with other webinars, blogs, materials about higher education topics, will be published there. Please feel free to use that QR code. All the materials are free and available to use. We hope they're helpful for institutions as they're navigating the vast regulatory changes that are taking place. First thing I want to talk about in this new rule is something that will be familiar to many institutions. Unfortunately, it's the regulatory turn that's happened from the Obama administration to the Trump administration to now the Biden administration, right? So we started with a Dear Colleague letter from the Obama administration to the Trump final rules to now this proposed rule. And for institutions that are acutely aware, kind of having to change policies during every presidential transition is not ideal. Unfortunately, that seems to be the path that we're stuck with for the foreseeable future. Complicating this is the ever-present threat of litigation. I think this is also another staple of the current regulatory landscape, as we're going to see in the future. 15 states now have currently filed suit against this rule. And so institutions are rightfully trying to figure out what their compliance strategies are, how much to look at this litigation, how much to handle when there's so much uncertainty here. Because of the short implementation time, we want to provide you this update to make sure that you're kind of going full speed ahead for compliance for that August 1st deadline, while kind of being aware of this litigation in the background. Remember, litigation could turn out to be nothing, could enjoin the rule completely, meaning it wouldn't be enforced, or could enjoin parts of the rule, as what happened in 2020. So it's worth keeping it in mind. We're going to do our best to keep the community updated on our blogs on the higher education resources page. But for now, until we know more, just to kind of know that this litigation is out there, it is complicating things, and it will be something that we're just going to have to deal with as we go on this journey together. First piece of the rule to explain, to understand, is that this version of the Title IX rule, as opposed to the Trump version, the current rule, greatly expands kind of what is covered under a Title IX grievance policy. Now, the scope of Title IX covering sex discrimination in general is not changed, but the Trump administration version had their grievance procedures narrowly focused on sexual harassment, used that definition, and then had kind of prescriptive procedures here. The Biden administration, as we'll discuss a little later with the grievance procedures, has stated that you have to have these procedures in place to address any complaints of sex discrimination. And what is really interesting about that piece is how the Biden administration's rules have expanded the definitions and concepts kind of relevant to the rule here. Now, on the screen, you'll see an overview, a heat map of definitions, concepts that were either removed or added or substantially changed. I'm going to highlight 3 of them for you right now. So the first is the term complaint, right? And so in the Trump administration version, in order to kind of start this Title IX apparatus, you needed a formal complaint signed by the complainant with the Title IX coordinator. Here, that is kind of that is now shifted to just the definition of complaint, which only requires oral or written statement for that an institution should reasonably believe would encourage them or will require them to kind of investigate and adjudicate in order to get the Title IX process started. The second is sexual harassment, right? And that's the same from the Trump administration to the Biden administration's rules, except that the Biden administration really kind of expands the concept of sexual harassment, in particular, the concept of what a hostile environment is. And under the Trump administration's rule, it had to be severe, pervasive, and objectively offensive in order to fit that definition. Here, the Biden administration has changed it to just require severe or pervasive conduct that could potentially, based on an objective and subjective read, dissuade someone or from experiencing the full education program or activity. So even a definition of sexual harassment that stayed consistent is broadened in this rule. And the last is kind of the general sex discrimination, which is not a definition as such, but is really the touchstone of one of the grievance procedures and kind of when an institution must initiate a process, right? Sex discrimination is both sexual harassment, which we talked about, and also discrimination based on sex stereotypes, sex characteristics, pregnancy-related conditions, sexual orientation, or gender identity. And this expansion, this definition is at the heart of a lot of these lawsuits. So stay tuned kind of if this changes or how this might change. Another important broadening of the rule to keep in mind is when it applies, right? So a lot of this should look familiar. A lot of the terms in black, it's based on education program or activity. It occurs in buildings potentially owned or controlled by the institution. But that first piece in red is a really important distinction. Title IX also applies under this new rule when it's conduct subject to recipient's disciplinary authority. So to the extent that an institution extends their code to address spring break or something that might have happened totally off campus that had nothing to do with it, this rule says Title IX also needs to apply. In addition, at the bottom there, this rule makes clear that even if conduct occurred when outside of the education program or activity, or even outside of the United States, if it contributed to a hostile environment based on sex, the institution might have an obligation to address it under Title IX. So very important to kind of know that the amount of conduct covered under Title IX is similarly expanded. In addition, a really interesting piece that we really need to kind of dig into more on our end too, but just flagging for the audience for now, is when when someone can and cannot discriminate based on sex. So under the Title IX statute, there are certain permissible areas where an institution can discriminate based on sex. For religious exemptions, housing, things like that, they're listed in the statute, they're written out there. But the department has said, absent that, even when permitted, sex discrimination or sex separation is permitted, it has to be done with no more than de minimis harm. And it's really important to kind of understand and kind of get your head around that, because that could lead to a lot of interesting decisions about policies, practices, etc., in order to ensure and understand what is permissible discrimination under the rule, what is de minimis harm, and what an individual kind of would be subject to or potentially complain about. Also important to note, in this section of the preamble, which is the explanation to the rules, the department makes clear that the proposed rule related to transgender athletics is not addressed in this section. It's forthcoming. That's, I'm sure, certainly going to be litigated and potentially more controversial. So stay tuned there, but that piece of the puzzle is still yet to be determined by the department. Another important difference here is when an institution is considered on notice of potential sex discrimination or sexual harassment, a Title IX violation, right? So under the Trump administration, it was actual knowledge. It was someone coming to the Title IX coordinator or a person with authority and saying this occurred and take action. That would be actual notice. That's when the institution would be obliged to respond. The important change here is that now it's any non-confidential employee who has information about conduct that reasonably may constitute sex discrimination. If you think about that, that's a very, very broad standard. That's a very big change. That could mean that your housing director that overhears a conversation about potential issues might now because of them overhearing that conversation, the institution is now on notice to provide remediation, to provide the Title IX apparatus, and to get started there. And that leads us into response requirements, right? So this rule also broadens when someone comes forward with a potential Title IX issue, what the institution has to do, what are their obligations. So there's a couple different categories of employees that the rule kind of describes: employees that can institute corrective measures, employees who have responsibility for administrative, teaching, and leadership. They must notify Title IX coordinator when the employee has information that may reasonably constitute sex discrimination. Then there's the kind of the general employment, right? So anyone who's not a confidential employee, they also have an obligation either to inform the Title IX coordinator or to provide the information of the Title IX coordinator. And then even confidential employees under this rule have an obligation. So they have to explain kind of what a confidential employee is, what they're doing, what they can and can't do, and also provide the contact information for the Title IX coordinator and an explanation of kind of what's provided. So everyone on your campus, every employee on your campus will have this reporting obligation. We'll talk about what training is required a little later, but suffice to say, for institutions that kind of we're able to kind of broadly or narrowly carve out certain employees that have Title IX obligations, this is a big sea change for institutions and a big change to think about your obligations under Title IX. Next is the Title IX, we call it the procedural waterfall, and this is just our way of kind of conceptualizing what Title IX has required, right? So there's here we're going to talk about three important sections of the rule. 106.44, which explains the institution's obligations, training requirements, etc., notice requirements when a complaint or an issue of Title IX comes into play. 106.45, which we refer to as the universal grievance procedures. So what happens when sex discrimination in general occurs, what grievance procedures are required to be provided. And then there's 106.46, which is an additional layer. So if there's sex harassment alleged with a student, additional procedures are required. So once notice is received, right, we talked about that in the slide previous, the Title IX coordinator is provided notice that under the rule that conduct is alleged that may constitute sex discrimination. Then there's a fairly detailed list of what an institution has to do to respond to that notice. And put in the note here, the Title IX coordinator's responsibilities are significantly expanded as part of this notice. So very important to be aware of that, especially if you're in that position, and what the rule would require a Title IX coordinator to do. If it's sex discrimination generally, making sure the institution has a grievance procedure that it follows, compliant with the rules, and then also making sure that if it involves a student, that all the additional pieces of the grievance procedures are met. So let's talk about those universal procedures. A lot of what's on this slide is going to look familiar to you. This has occurred in previous iterations of the Title IX rule, in addition to the Trump administration's rule. But here we're talking about equitable treatment, making sure there's no conflicts of interest, a presumption against responsibility, reasonable timeframes. Again, the concept stays, but there's more about reasonable timeframes in this rule for everyone to digest and kind of what's required. Protection of privacy, specific requirements there. How to evaluate relevance and credibility, especially when that's at issue, and how to exclude and when to exclude certain evidence as part of an investigation. In addition, if a student is involved in sex harassment, there are additional procedures required here. Notice, advisors, there's pieces about expert witnesses and extensions, evidence and credibility. Briefly, I'll touch on a couple of these. So first, under credibility, one of the big pieces of the Trump administration rule was a requirement that a live hearing occur with the ability to have cross-examination. Unless a state law requires that, this rule kind of does away with those requirements and just says that you have to have a process in order to question witnesses, establish credibility. The old single investigator model is certainly potentially in play here, and institutions have to decide what the right process is for them, be it the live hearings and cross-examination, a live hearing with maybe a little different kind of a way to question witnesses and parties, or the single investigator model. And there's certainly pros and cons to each, and that's kind of part of the initial decision making that an institution is going to have to do. In addition, if you remember, there were certain prescribed timeframes on when evidence needs to be provided, how much evidence to be provided. That is not the case here. There is requirements about evidence. They are lessened, and so certainly worth an institution's buy-in to figure out what evidence they're going to provide, how they're going to do it, and kind of what they want to build into their procedures, both to comply with this rule and also to protect against any potential litigation or challenges, et cetera, that might come to fruition. Training requirements, another big expansion of the rule potentially. And so under this rule, there is a requirement, as on the slide, for all employees to be trained, right? The institution's obligation to address sex discrimination, the scope of what constitutes sex discrimination and sex-based harassment, and applicable notification and information requirements under the regulations we talked about, and also pregnancy and marital status, those pieces of the regulation, which we'll talk about toward the end of the presentation. In addition, there are just the traditional requirements, or not traditional, but the ones kind of previously there are stayed for investigators, decision makers, others responsible for implementing grievance procedures. They have specific training requirements. Facilitators of informal resolution, they have specific requirements, as well as Title IX coordinators. So training is going to be a big piece of what has to happen between now and August 1st in order to become compliant with the new rule. Finally, toward the end, while pregnancy and related conditions has always been a part of Title IX, it's always been kind of within the rule. This rule specifically calls out what types of pregnancy, what types of conditions would be covered under the rule, and what an institution needs to do in order to satisfy their obligations under Title IX, be it providing reasonable modifications and accommodations, reasonable break times, et cetera. And so that is a really big push of the administration of the rule to kind of add this specifically, add these requirements specifically into the regulation. Also, notification requirements, as we mentioned, when an employee is informed of this, there are obligations to discuss this with the Title IX coordinator and to make sure that that an institution is aware and is able to take action consistent with the law. Next steps. So that was the highest of high-level overviews. Hopefully, The big takeaway here is there's a lot to do between now and August 1st. If you're like us, you're reading the rule, you're trying to figure out kind of who's on your team, what the best course of action is, what the rule actually says. But the biggest takeaway, right, from this whole thing is that there's a lot of change. The rule is going to create a lot more kind of potentially covered conduct under Title IX, and it's incumbent on institutions to try and find a way to make sure they're prepared for the deadline of August 1st. And that is going to include a new Title IX policy, notice of non-discrimination, and grievance procedures, right? And as I mentioned before, there is a resource for drafting. It's a good first start, and certainly would encourage everyone to take a look at that. Training obligations for employees, that's another big piece of this. Make sure that you kind of have that figured out, and especially with summer break coming up, how to get those employees trained, what the process is, how to make sure that those employees get the right information, and also employees that are going to be part of the process, right? Are they leaving? Like, how do we get enough people, enough buy-in, right, in order to make sure that employees, students, administrators, et cetera, everyone's happy with the new process, or as much as happy as they can be, right, as it's rolled out for the upcoming school year. Finally, again, there's our TC extra credit. Mention that again. This presentation and all of our Title IX materials and other higher ed materials will be up on that page. So certainly encourage you to take a look at that at your leisure. And with that overview, I'll say just thank you guys for sticking with it, for joining. There's more to come on this rule. We're happy to do it. Finally, the disclaimer at the end: we're not your lawyers unless we're your lawyers, and we're happy to assist anyone that has any questions about Title IX or the process moving forward. Till the next Reg Rundown. Thanks all.